Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come here this morning for an arraignment. What an arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in County Court at Law number 2 is a misdemeanor case. Criminal cases are classified as either a felony or a misdemeanor. Your felony cases are normally referred to as your more serious type of criminal offenses. Your misdemeanor cases are normally referred to as your petty offenses. Does not mean that it's not serious, it means that it is not as serious as a felony offense. And the reason why I say serious is because the difference between the felony and the misdemeanor is the range of punishment. That is, the punishment that you can get after being convicted for the offense. If you have a felony offense, your felonies are divided into 5 categories. It will be either a capital murder, a first-degree felony, a second-degree felony, a third-degree felony, or a state jail felony. If your offense is a state jail felony, which is the lowest felony, the range of punishment is 2 years in the state jail to, 6 months to 2 years in the state jail, a fine up to $10,000. If you have a third-degree felony, which is a step higher, the range of punishment is 2 years minimum to 10 years in the state penitentiary, a fine up to $10,000. If you have a second-degree felony, the range of punishment starts at 2 years minimum to a maximum of 20 years in the state penitentiary, a fine up to $10,000. If you have a first-degree felony, the range of punishment minimum of 5 years up to 99 years to life, fine up to $10,000. And the highest felony that we have in the state of Texas is a capital murder. And if you have a capital murder, the range of punishment, if you are convicted, is life or death. Now, for the misdemeanor offenses, they are divided into 3 categories. You have a Class A misdemeanor, a Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanor is your lowest misdemeanor. For a Class C misdemeanor, the range of punishment is fine only. You only can be given a fine. You cannot be given any jail time. We go up a step higher to a Class B misdemeanor. The range of punishment is 0 days to 180 days, which is 6 months in the county jail, a fine from $0 all the way up to $2,000 or anywhere in between. If you have a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is 0 days in the county jail, all the way up to 365 days, which is a year, or anywhere in between, a fine from $0 all the way up to $4,000 or anywhere in between. So that's the range of punishment for your misdemeanors. Your case is either a Class A, a Class B, or a Class C misdemeanor. If your case is a Class C misdemeanor, that simply means that you're here because your case was appealed from the Justice Court, which is the JP Court, or the Municipal Court, which is the City Court. We only handle Class C misdemeanors when they are appealed from either the City Court or the JP Court. As a defendant in a criminal case, you have a right, you have rights. One right that you have is you have a right to have an attorney. That document that has been handed out to you states that as a defendant in a criminal case, you have 3 options. One, you may hire an attorney. Or number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your signature on the line that says defendant, and you will place today's date on the line that says date. And today's date is January 25th of 2022. The second page on the clipboard is for individuals who will be representing themselves. That is, those individuals who have initialed the 5th line stating that you want to waive your right for an attorney and represent yourself. And if that's your case, then this applies to you. And it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 25th day of January of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you will sign on the line that says defendant, and you will place today's date where it says date, January 25th of 2022. Now, as a defendant in a criminal case, you have other rights as well. You have a right to have a trial by jury. That area that that's sitting over there with those 12 chairs in it, we call that the jury box. 12 citizens, or actually in a misdemeanor case, 6 citizens from Jefferson County will be selected to sit on your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in your case. Now, you have a right to waive your right to have a trial by jury or to give up your right to have a trial by jury as well. And what that simply means, if you waive your right to have a trial by jury, then you would not have a jury trial. And your case can come before the judge or before the court in one of 2 ways. It could come before the judge by way of a trial or a plea. Now, if it comes before the judge by way of a trial without a jury, we call that a bench trial because it's a trial before the judge only, and the judge will be the judge and the jury in that case. And the judge will also assess punishment. If you desire to enter a plea, and what a plea is, if you have reached a plea bargain agreement with the state, and what that means is you have reached an agreement to settle your case with the state of Texas or with the district attorney's office, we call that a plea bargain agreement. Then your case will come before the judge, and the judge will decide whether to follow the plea bargain agreement or not follow the plea bargain agreement that you have made with the district attorney's office. If the judge does not follow the plea bargain agreement that you have made with the district attorney's office, then you have a right to withdraw or take back your plea. Now, if the judge does follow the plea bargain agreement, and if you decided that you want to appeal your case, you would have to get permission from the judge. And if the judge gives you permission to appeal your case, then your case will be appealed up to a higher court than this court. That court is called, in this county, it's the Ninth Court of Criminal Appeals, which is on the 3rd floor, right above us. They'll decide whether or not to grant or deny your appeal. If they grant your appeal, then they can set aside the conviction, find you not guilty, or they can order this court to give you a whole new trial. If they deny your appeal, then you can appeal it up to another court, a higher court than the Ninth Court of Appeals. You can appeal it up to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeal. You would have to file what is called a pro se petition for discretionary review. And what that simply means is you will be representing yourself without a lawyer. You'll be asking the Court of Criminal Appeals in Austin, Texas, to determine whether or not your appeal should have been granted, whether or not you were wrongfully convicted, or whether or not this court committed an error by convicting you. If they grant your pro se petition, then they could find you simply not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. Or if they find, or if they deny your case, then at that point your conviction will stand. Now, I stated earlier that your case can come before the judge if you decided that you did not want to have a jury trial by either, it could come before the judge by way of a bench trial or by way of a plea agreement. And the first plea, there are two types of pleas, agreements. One would be an agreed plea bargain, and that's what I mentioned earlier when I told you that if the judge doesn't follow it, you may have a right to appeal. The other way is you have what is called an unagreed plea bargain agreement. What that means is here, an unagreed plea. What that simply means is that you and the state or the district attorney's office have not been able to reach a plea bargain agreement to settle your case, but therefore you want your case to come before the judge for the judge to decide what the punishment is going to be in your case. We call that an unagreed plea. Now you also have other rights as well, besides the right to have an attorney and the right to have a jury trial. You have a right to have witnesses to come to court to testify for you or against you. And witnesses, they sit in that chair over there. We call that the witness stand. As I said earlier, they could testify either for you or against you. You have a right to waive or give up your right to have witnesses in your case. And if you waive your right to have witnesses, then that just simply means that you will not be calling witnesses. However, the state will be calling witnesses in the case that they have filed against you. You have a right against self-incrimination. And what that means is you have a right not to testify in your case. You may have heard the term, I'll take the fifth, which means you have a Fifth Amendment right against self-incrimination. Now, if you exercise your right, your Fifth Amendment right against self-incrimination, that simply means that you will not be testifying in your case. Now, if you also have a right to waive your right against self-incrimination, which means you have a right to give up your right against self-incrimination. If you give up your right against self-incrimination, that means that you will be testifying in your case. You also have a right to have discovery. Discovery is you have a right to see the evidence that the state has against you. Whatever evidence the state has against you in your case, you have a right to have access to that evidence. If you're represented by an attorney, your attorney will have access to that evidence. If you are representing yourself, then you will have access to the evidence. Now, you have a right to waive or give up your right to have discovery. That just simply means you have a right not to have access to the discovery. In essence, you do not want to have access to the discovery. You have a right to waive or give up your right to have discovery as well. Now, everyone that's here today, you're here because you're out on bond, and that is you've been arrested and you're bonded out. Either you've been given a PR bond, you paid a cash bond, or you have a surety bond. So you are out on bond. Every day that you spent in jail, you can get credit on that toward your punishment. Every day that you spent in jail, if you have, if the state is offering you a fine, every day that you spent in jail, that's credited as $100 per day toward your fine and your court costs. Now, you have a right to enter one of three types of pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting your charges. Now, if you enter a plea of guilty, no contest, then your case will be disposed of. If, as I said earlier, you have, if you work out a plea bargain agreement with the state, for example, let's say you spent 5 days in jail and the state is offering you to serve 5 days in jail. What that simply means is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Let's say that you spent 5 days in jail and the state is offering you a fine and court costs of $500. That simply means that you will not have to pay the $500 because the time that you spent in jail, the 5 days, is equivalent to $500. Therefore, you'll be given credit of $500 and your fine and court costs will be taxed and retired. Now, if you was offered 6 days, you did 5, that means you had one more day to do. If you was offered a fine and court costs of $600 and you spent 5 days in jail, that means that you have to pay $100. Now, if you can't pay the $100 on the day of the plea, then we can put you on what is called a payment plan, or you could pay it off in installments. If you cannot pay it off at all, then we can convert your balance of your fine and court costs to community service. And what that means by community service, you'll be able to work it off by every hour that you're doing in community service is you get $12.50 that go toward your fine and court costs. So if you work an 8-hour day, 8 hours of community service, that's $100 that will go toward your fine and your court costs. Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. So if this is your first time getting into trouble, they have a program whereby they will dismiss your case and you can get it expunged, which means erased, deleted, or wiped off from your record. And the way it works is it cannot be an offense involving unlawfully carrying a weapon or possess or a resisting arrest. And it got to be your first offense. You cannot have a criminal history. And then the third thing, you have to get an attorney to assist you with getting into the program. So if you get into the program, the case is dismissed, you complete the program, you can get it expunged, which means erased, deleted, or wiped off of your criminal history. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program that is called Veterans Court. Veterans Court is for veterans only. If you get into the program, it's part of the pretrial diversion program, your case is dismissed, you complete the program, you can get it wiped off, erased, or deleted from your criminal history. And the criteria is you have to be a veteran to get into that program. Now, this court, County Court at Law number 2, has a program that is called Community Safety Initiative, which is short, well, it's CSI. We call it the CSI program, which stands for Community Safety Initiative. And that program is a program designed to address the issue of what we call recidivism. Recidivism means that when people commit crimes over and over. And the way we address that is by addressing the cycle of violence, or the cycle, and the cycle basically starts off by individuals who do not have an education, normally can't get a job. They can't get a job, they usually turn to drugs and alcohol. Once they turn to drugs and alcohol, they may eventually commit a crime. If they commit a crime, they eventually get caught. And if they get caught, they will do time. And once they do time, they will get out. And when they get out, they're back into the cycle. And so we address the cycle with our community safety initiative because we have partnerships with agencies in our county and in our area. We have a partnership with Spindletop, and we have individuals in court today from Spindletop who will be able to talk to you later on. But with Spindletop, Spindletop is our local mental health agency. Spindletop, they can come in and do interviews. They can give you a private interview, do an assessment. They can develop a treatment plan for you, either outpatient or inpatient. And for individuals who have issues with drugs and alcohol, Spindletop has a youth program, 21 years old or younger, and that program is ATAR. ATAR stands for Addiction, Treatment, and Recovery. With that program, individuals who have issues with drugs and alcohol, they can be interviewed, they can be given a screening, and they can develop a treatment plan, either outpatient or inpatient. And for individuals who are 21 years or older, OZAR, which is our local mental health, our local drug and alcohol council, they can also provide services where they can do screenings, develop a treatment plan, either outpatient or inpatient, for individuals who have issues with drugs or alcohol. Now, if you're unemployed or if you have a low-paying job and you want to get a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Commercialization Entrepreneurship. It's a job training program that addresses individuals who do not have jobs. And the program CICE is Center for Innovation, Commercialization, and Entrepreneurship. They give you job training in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you need to get a GED, they have a program where you could get your GED as well. And once you get your GED, then you could get into that program. And as I said earlier, they will give you training in either the hotel industry, shipping industry, or the chemical industry. And once you're trained in those areas, they will assist you at getting a job in the area in which you're trained at. Now, All of those programs that I have just mentioned, the mental health program, drug and alcohol program, the GED program, the job training and the job placement program, all of those programs are free. It does not cost you anything. And all of those programs can be used as community service toward your punishment. So for example, let's say you was given a fine and court costs of X amount of dollars, and you're in one of those programs. Say if you get job training, the mental health treatment, or drug and alcohol counseling, or GED, either one of those programs, every hour that you are in that program, that hour will go, 1 hour will go to our community service, and $12.50 will go towards your fine and court costs. Okay, so you're killing 3 birds with 1 stone. You're in the program, you're doing community service, and you also paying your fine and court costs. Okay, and as I said earlier, all of those programs are free, does not cost you anything. All thing that you have to do is have a desire to want to be in the program. Now, I tell people this all the time. These programs is a program that we started, or that I started, called it the Csi Program in March of 2017. And that program was designed to address the issue of recidivism. The programs, the only thing you have to do is have a desire to be in the program. We tell people this all the time. When you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County, the county in which we live. Also, all of these programs are designed to address the issue. We tell people this: when you come to county court at law number 2, we do not just give time, we take our time, and we do not just arrest the issue, we address the issue. And so we believe that if we address those issues, we can produce productive people. And we believe that producing productive people for the most part will not commit crimes. Therefore, Jefferson County will be a safer place for all of us to live, work, and go to school. Now, the forms that's been handed out to you, we'll go over that with you in a little bit. We're going to pick that up. But before we do that, we have Deputy Hinton, who is a mental health deputy in Jefferson County. He's going to come before you and tell you something about the program that they have at Spindletop. Deputy Hinton.
Thank you, Ron.
What? Hold on.
Good morning.
Hold on a minute.
My name is
Hold on a
Steve
minute.
Hinton.
Let
I'm
me
a
talk to you.
mental health deputy licensed by the state of Texas. The reason I am here, also
Yeah.
qualified mental health professional. The reason I'm here today is because the judge cares about every single person who comes before his court. And what the judge has found is those people, more so than not, who come to his court commonly have either mental health issues or substance use disorders that are causing their legal issues. The judge believes if we can address those underlying issues, such as mental health or substance use disorders, we can get you out of that cycle of arrest. Should this be the first time you're in his courtroom or the 10th time that you're in his courtroom, there are services, there's options, there's opportunities for you to get you out of the cycle of arrest. So that's what we want to provide you today. But it's going to take a bold act on your part, because you're going to need to share the information with us so that we can best direct you in getting the services that y'all need that would be most beneficial to you and your situation. And maybe this doesn't apply to you, maybe it applies to a family member. We'd still like to get this information to you so you can take it back to them and help them. We'd be glad to work through y'all to get to the family member, to give them the help that they need. But again, it's up to y'all. Now, at the very least, I want to get this brochure in your hands. If you ever find yourself in an unsafe place, it has a 1-800 number on here. You can call and get help immediately. There's also a number here for Spindletop if you want to get into services. Then you can call that number as well, and we can also assist you in working through that. Now, as the court goes to recess, I'll be visiting with everyone out here. I'll get you one of these here. If you want to talk, want to leave your phone number, we'll be glad to visit with you about yourself or about a family member It's up to you. Everything is voluntary. Everything is HIPAA regulated. Your information is private. Won't be shared outside your own permission. But we're here for y'all if you want to take advantage of that. Thank you very much. Thank you, Ron.
All right, thank you, Deputy Henry. Okay, ladies and gentlemen, our court staff is going to pick up the paperwork that you have, and it's gonna take us some time to go through it. So we're gonna be in recess. And